Yes, good afternoon, Mr. Gibson.
Lord. My Lord, before we return to undertakings, just to close on case management table and disbursement table, I took you to the case management table in order to show the court the extent to which the evidence in relation to how this case would be funded was deployed, having regard to directions which the evidence showed it was likely the Malaysian court would make, and that the case management table drew those together from all the evidence. There's then the disbursement table, which it's not necessary to go to, which is at core supplementary divider 13, page 446. I'll just make a few submissions about that in the light of what was said yesterday. This provides estimates of the disbursements arising from the case management table. It is not a costs table. It doesn't purport to go into what different steps in the litigation might cost. So it's based on a split trial and 3 test cases on liability. It was also put together in the form of a Scott schedule so that the claimants could posit alternative figures. And they didn't do so, and they still haven't done so. The defendant's calculations are based predominantly on the claimant's own evidence as to court costs, as I say, the case management model and the undertakings. So the low figure, which then, as you'll recall, the judge found would have to be covered potentially by NGO of 328 or 374, nothing turned pounds. About the ringgit figure I'll come back to, but it's the 328 or 374 pounds. It was not disputed that that figure would not be payable by the NGO, accepted they could pay that figure. And the judge, as you'll see when we go to it, found that there would be NGOs well able to pay that figure. Their essential point, and the point on this appeal was, well, the disbursements would have been greater, but they wouldn't have been greater because the disbursements are not the issue. It's a red herring. The disbursements cover the court filing fees and the costs of making applications. The reason that they're low, as your lordships have identified, I appreciate, is that they don't include the matters that are covered by undertakings. And the undertakings, of course, reduce the likely disbursements and lawyers' costs. So the 3 points that are taken by the claimants...
Sorry to slow you down, but I'm not entirely myself understanding the distinction for Malaysian lawyers between disbursements involved in paying for the court fees and disbursements that might be payable during the course of the case more generally on all aspects of running a case. You've got profit costs, but you've got disbursements in running a case.
Well, it's accepted that the disbursements not covered by that table and not covered by undertakings would have to be paid by the lawyers on CFAs.
Yes.
That is accepted. But it was suggested that the disbursement table was unrealistic and so on. It's based on the claimant's own evidence, and it relates to particular disbursements of particular steps. And the only criticisms that are now made of it, and I can deal with them very shortly, are it only provides for 3 witness statements, it said, which is too few. In fact, that's the subject of an undertaking by, and I'll come to that, by the defendants, which is unlimited in number, so that doesn't go anywhere. It said that it's based on court proceedings of 10 days. That's a misreading of the disbursements table. It doesn't say that. And it says that it's based on only 3 specific disclosure applications, which is correct, but there is provision in the table for 3 further applications, and the short point is the sum involved is only £28 anyway, because it's just the cost of making the applications, so that doesn't go anywhere, which comes back to your lordship's point, which is what I appreciate is key to the funding issue, is whether there was sufficient evidence for the judge that Malaysian lawyers would fund the costs and any other disbursements such as the costs of an expert in relation to the unjust enrichment claim, while operating on a CFA. And we say the evidence was overwhelming they would.
But conversely, common ground that they wouldn't bear the disbursements that we're talking about.
Yes.
That's what puzzles me, really. That should be a distinction that arises, but if that's what the evidence was,
well,
the evidence was.
I mean, they may, but they're so small it doesn't really make any difference. It could be it's £374. But the important point I see to make here is it's a very small figure. Nothing turns on this disbursement figure.
Thank you.
Then we come to the undertakings. As we've been discussing, the claimants criticised the judge's reliance on the undertakings. And those undertakings are at Core Bundle Divider 6, page 74. They were exhibited to the order of the court. They're also at paragraph 16 of the judgment in similar but not precisely the same form, because the order itself broke them down into sub-undertakings, but there's no difference in substance. And as I understand it, there's no criticism of a number of the undertakings. 3A, 1 and 2 are the undertaking to submit. 3A will not seek security for costs, will not seek adverse costs against the claimants in Malaysian proceedings if and to the extent that such costs would not be recoverable under the Quok scheme in England. That's to ensure there's equality in relation to the cost position. And then the two that have been the subject of discussion, the only two, as it were, evidential undertakings, and it's C. The defendants will pay the reasonable costs necessary to enable the claimants to give evidence in the Malaysian proceedings, including affidavit affirmation fees, other costs necessary for the claimants to give remote evidence, including travel, accommodation costs, costs associated with the provision and set up of suitable video conferencing technology, translation fees, and other costs and so on. You've seen that. Defendants won't oppose an application for remote attendance, will pay the claimant's share of court interpretation fees, transcription fees, and joint expert evidence. Will not seek to challenge lawfulness of any success fee arrangement. Will not oppose an application for a split trial. So, as you can see, there's a number of the undertakings which I understand are not opposed, are simply designed to facilitate, in a fair way, the trial of the proceedings in Malaysia on the same terms as they would proceed in this country, for example, in relation to adverse cost orders. But the two relating to evidence, the undertaking at E is simply that they will pay court interpretation fees, transcription fees, and joint expert evidence, and the reasonable costs necessary to enable the claimants to give evidence in Malaysia. Those are, we would respectfully submit, of a essentially logistical nature. This is stage 2, so the court has already on this premise concluded that Malaysia is the appropriate forum. We submit it's in the interest of justice and the interest of the parties to take account of undertakings. The defendant's position is that it is seeking to pursue the legitimate interests of ensuring the proceedings are heard in Malaysia. It's the easiest way to hold ATA responsible, if they are responsible, to sue them in Malaysia. That's ATA's domicile and the place of the claimant's employment, where the employment and wages records are to be found, and the location of any direct witnesses to the abuse and other matters alleged. It's the only place where it's possible to sue the police if that's necessary. It's the place where the contractual indemnities can be deployed against ATA. So those are the legitimate reasons we respectfully submit for giving the undertakings, and why it is plainly in Dyson's interest to comply with them, not that they would fail to do so, having given them to this court. They don't fund the claimant's action. They address the acute and unusual disbursements which arise in this case, because the claimants are not by and large in Malaysia and do not speak either English or Malay. So there's a unique issue, and they deal with those special unique issues, these unique geographic and linguistic problems. They don't cover profit costs, they are just the disbursements. It's in Dyson's interest, as I've explained. They can be policed by the Malaysian court. Any argument as to reasonableness would obviously be determined at the close of the proceedings.
But how is that a matter for the Malaysian court? These are undertakings given to the English court.
Well, the reasonableness of the disbursements in the course of the Malaysian litigation. If it was said they weren't reasonable, in my submission, that would be a matter for the Malaysian court as well, having regard to its general regime to ensure that costs are fairly allocated.
It wouldn't be determining any costs. It would be deciding whether costs in question, let's say of a claimant's witness going to Kathmandu rather than their local town, were or were not reasonably necessary.
That assumes that there was.
And that's a question not for taxation, as we used to call it, assessment of costs within the proceeding, but whether you should pay for it pursuant to an undertaking to the English court. Is that reasonably necessary? Surely that's got to be policed by the English court.
Well, as a fallback, it could be, but it just, in my submission, one's entitled to take a pragmatic and realistic, if I may say so, approach to this. And if at the end of the proceedings there is any issue at all, and it's assuming there is, and there's no reason why there necessarily should be, it would obviously be open to the parties for that question to be determined in Malaysia.
You say pragmatic. Suppose they said to the Malaysian court, can you please decide that it's reasonable for C23 to go to Kathmandu, say. The Malaysian court will say, well, we're being asked to decide that now, for the purpose of the undertaking. And your clients would, if they're entitled to do everything lawful to promote your client's interests, would say, we haven't given any undertakings to the Malaysian court, you'll have to go to England to fight that issue.
That is where...
What's to stop you doing that?
Well, that's where I respectfully take objection, because that is assuming an act that is contrary to the Dyson defendants' interests in ensuring that the proceedings remain in Malaysia, and is also assumes a degree of unreasonableness that in circumstances where whichever jurisdiction it is, the Dyson defendants you can proceed on the basis will abide by the letter and spirit of the undertaking. And
what do you mean by the spirit? If your clients quite properly take the view that it's well arguable that the costs are not reasonable or not necessary, why should they agree to have that matter dealt with by the Malaysian court? Surely it's in their interest to say, I'm sorry, we haven't given an undertaking to the Malaysian court. Why when your clients consult their solicitors, would they not get the advice? There's nothing in this that says you have to.
Because that is the obvious, efficient and cost-effective thing to do.
Well, you haven't undertaken to do everything which is efficient and cost-effective. You've given specific undertakings to the English court. Now, the English court can enforce this.
Well, that's why...
That's one of the difficulties I see, anyway.
Well, that's why in our submission the court is entitled to take a pragmatic approach. And the fact is, on this premise, the parties are before the Malaysian court, and therefore it is in the parties' interests and it's in Dyson's interest to ensure that any dispute on this hypothesis of reasonableness is determined by the Malaysian court. If there is some ultimate fallback that the claimants come back and seek to present a case to the English court that the Dyson defendants have acted unreasonably, well then that is an ultimate fallback. But in my submission, it's not a realistic. It's not a realistic position. We're positing the end of the litigation. The overwhelming probability is that there'll be no issue about it at all. But if there is, that the parties will want it sorted out in Malaysia.
Can I raise another problem? How do you deal with privilege? If the claimant's lawyers come to you and say, we'd like to spend X, and you say, how exactly are you going to be spending it? Which particular claimants are going to be coming to give evidence? They have to tell you, do they?
No.
In order to get the funding?
No, they don't. We cannot take any step, clearly, which would reasonably require, and this would be inconsistent with the undertaking, to take a step which would involve any express or implied waiver of privilege.
So you would then just have to pay whatever they ask?
Yes.
Irrespective of whether it was 15 times as much as you think might be the ordinary costs of moving everybody to
Yes.
a video conferencing centre.
Yes, because we couldn't reasonably, having given these undertakings, expect there to be an inquiry which caused any waiver of privilege.
So we should read these actually as an undertaking to pay unreasonable costs which aren't necessary, as well as reasonable costs which are necessary.
It's an undertaking to pay reasonable costs, but it's implicit in that undertaking that there would be no inquiry that involved a waiver of privilege.
Sounds quite unwieldy.
Well, in a sense, that's my point, that we're assuming problems which the overwhelming probability, I would submit, are not going to arise, because the costs that we're talking about are likely to be so small. We're talking about the costs of setting up remote evidence in Kathmandu, travelling to Kathmandu. I mean, they're logistical costs, and taking witness statements.
Or Bangladesh or some other country where they may be by the time of the trial.
I mean, what is small to you may not be small to a migrant worker in Kathmandu.
But we're paying for it.
Or not. It's the problem. If you don't pay for it, it's a problem.
Well,
anyway, I'm sorry.
I mean, this privilege business. I mean,
we've undertaken
the answer you gave, Mr. Gibson, to my lord, when you accept it, they don't have to tell you which claimants is going to give evidence and what the expenses are for, and there can be no waiver of their claimant's privilege.
that must be right.
We'll just have to pay what they ask in respect of witness expenses. Looks to me to be really more than unwieldy. It looks to me to be unworkable as an undertaking that can be policed by anybody, doesn't it?
Well, the undertaking I would accept cannot involve the claimants having to justify through the waiver of privilege monies that they have incurred. It follows from that the policing of the court would have to be on the basis of unprivileged material. There could still be, if they came out with a completely irrational sum, then
you'd make inquiries as to what it would be for, and they would say, we can't tell you because it would waive privilege. And then where do we go?
well, then that has to be paid.
Sure,
So this works against
on the other side of that.
Well, they can hear what I'm saying. This works against Dyson. This isn't working in favour of Dyson. It works against Dyson in terms of finances.
I mean, one could be forgiven for thinking it simply doesn't work, Mr. Gibson. But you say it will. And I have a note of that submission.
Well, I am being pushed on the basis of what I would respectfully say is an assumption that Dyson are going to take steps, or may wish to take steps, which would not make economic sense in circumstances where these are very likely to be not significant costs. But faced with that, that is my response.
Can I raise another point, which is one that's occurred to me, although it hasn't been raised, which is in the undertaking, everything is by reference to these claims, which are defined as the claims issued in these proceedings and particularised in the current particulars of claim. Now, if, as Lord Briggs obviously thought was blindingly obvious, disclosure is going to be key, and if, as one might envisage, there's at least a real possibility, to put it at its lowest, that the pleadings will be amended, or the allegations will be put in an amended way. Do these undertakings cover the amendments?
They'd have to be amended to cover that.
The undertakings would have to be amended.
Well, no, the people to whom they apply would have to be amended to cover the new claimants.
Well, I wasn't so much thinking of new claimants, but simply the way the claim was expressed. So if then in relation to giving a particular part of the claimant's evidence, or particular aspects of joint expert evidence, or court interpretation fees, or transcription fees, or any other cost, if that could be attributable to the amendment in the pleading, fall outside the scope of the undertakings?
Well, that's not a point that we've expressly considered.
It seems to me it plainly does on the wording. It's been, the undertakings have been offered in relation to these claims, meaning what is currently particularised.
Well, that is what is the subject of the current jurisdiction application.
It is, and it's not necessarily. I'm not necessarily saying you could have done something different. I'm saying it's a problem with them. They don't meet all the eventualities that they would have to meet. That's the point that I'm making.
Well, my response to that would be that the court is entitled to, at this stage of the jurisdiction application, to proceed on the basis of the claims as pleaded, and it's perfectly reasonable and fair to reach a decision having regard to the undertakings in respect of that pleading. And the court shouldn't speculate as to whether the pleading might be amended or indeed other claimants might come forward.
Sorry, I interrupted your flow.
No, you're right.
Thank you.
Grateful. So, I mean, in summary, as I've said, and forgive me for repeating because it's obviously an important matter for the court, we respectfully submit that the court should proceed on the basis that the defendants will not commit contempt and resign on its undertakings, that it will act reasonably, that it has legitimate interest in doing so, and that therefore, although there may be potential technical issues of the type we've been discussing, the overwhelming probability, which it's reasonable to act on, is that any issues which do arise can and will be sorted out by the claimants and defendants, either by agreement or, if not, with the assistance of the Malaysian court. So, my lords, those are my submissions on the undertakings, and I appreciate they're obviously, as I've said a number of times, crucial to the financing of the case. But key criticisms are made of the judge's reasoning in relation to actions of justice, to which I must now turn on the assumption that the undertakings hold good. Round 2A continues at the claimant skeleton 43.1 to the effect that the defendant's approach would require a Malaysian lawyer to personally incur costs of translating documents and evidence into the claimant's language, and also forensic accounting costs. There's no evidence that any lawyers will be willing to fund such claims. So this is one of the many examples where actually the attack on the judge's findings in relation to funding and availability of lawyers boil down to quite narrow points when you analyse them. We respond to this in paragraph 43 of our skeleton, and dealing first of all with the forensic accountant's costs, which we address in paragraph 44. As I said to you this morning, the possible need for forensic accounting expert was not canvassed in written submissions or evidence, it was raised in the claimant's oral submissions on day 3 of the hearing. In the circumstances, it's not surprising that the judge said in his judgment that there's no evidence of any lawyers who would be willing. Sorry, it's unfair to criticise the judge by saying that there's no evidence of any lawyers who would be willing to fund such costs. In any event, it's a bad point, as you can see from paragraphs 134 of his judgment, and 137 and 138, where he dealt with the forensic accounting costs, and as your lordship, my Lord Justice Popplewell noted in 134, having made points about those costs, he said that would require some evidence and analysis, but it would be very surprising if the time devoted to this was extensive, given that the claim involves only 24 workers, and there'd only be 3 lead cases. There was no evidence presented to the courts to suggest otherwise, and I drew your attention to the fact there's no evidence to the court to suggest otherwise is because it was raised orally late in the day. And then 137, page 111 of the bundle, with respect to the unjust enrichment claim, there's no evidence was put forward on this point by the claimants as to what would be required to advance this case. And he accepts that there may be a requirement for limited forensic accounting evidence. So there's no appeal against these findings, and on the basis of the judge's findings, in circumstances where the claimants had adduced no evidence as to forensic accounting costs, he's made findings that they would not be significant. And they therefore are costs which can reasonably be met by the notional lawyers acting on CFAs. Moreover, there was evidence that lawyers do pay for disbursements in Malaysia, which the judge referred to in paragraph 161 of his judgment, where he said, former Judge Kwai also expressed the view that there was no prohibition on disbursements being funded by law firms, so long as there's a basic fee to be paid with a success fee along with the disbursements. And the reference for that is SUP Divider 10, 180 to 181, page 8, paragraph 81. Tony Woon, who I'll take you to in a moment, the chairperson, Malaysian Bar Council representative, is also referred to at paragraph 164 of the judgment, where the judge, accurately reflecting his evidence, says he explained that it was often necessary for lawyers acting on success fee arrangements to fund the disbursements for their clients. That is a point made in paragraph 15D of Mr. Woon's statement at supplementary volume 1, divider 13, page 237. So we respectfully submit there's nothing in those two criticisms related to those particular costs and the failure to take them into account. Then at their skeleton at paragraph 43.2, they attack the conclusion that NGOs would fund all disbursements not funded by the defendants or the claimant's lawyers, and they say that was not supported by the evidence. But this challenge again is on analysis very narrow. It is that the judge wrongly discounted the NGO's evidence because he erroneously accepted the defendant's calculations as to the small amount of disbursements that NGOs would be required to cover, what he called the 328 1,916 ringgit gap. So this is essentially an attack, a further attack on the likely scale of disbursements. In short, the claimants are not contending that the NGOs could not fill the gap calculated at the level that it was by the judge. And indeed, there's no challenge to the judge's findings at paragraphs 148 to 155 of the judgment, and in particular to his conclusion. But this is another area where he rejected evidence as being less than cogent because of the erroneous premises on which it was based. And you see that by way of example, where he starts dealing with there was no cogent evidence that the gaps could be filled by the NGOs at page 114 of the core bundle, at paragraph 148. He carries on looking at the claimant's evidence, in particular notes the evidence of Mr. Pereira from a NGO called North-South Initiative. And again, makes the point in the penultimate sentence that Mr. Pereira's evidence was premised on the ANSI having to pay for all or the bulk of the disbursements. That would not be the case, given that the Dyson defendants had undertaken to pay for most of the disbursements. And that's generally the criticism that he raises before of the claimant's NGO evidence in a number of respects. And there's no challenge to that. And then he pulls it together in 155, saying that it's highly likely, 154 first of all, it's highly likely that one or more of the several NGOs that support migrant workers in Malaysia and fund some of the fees and disbursements would fill the relatively small gap in funding required by the claimants to prosecute their claims. The risk that the NGO community would not fill the gap is unrealistic. And then in 155 he gives his reasons. Several NGOs that do support migrant workers, whose very purpose is to support such workers. Several NGOs provide some funding for legal cases. The claim against Dyson defendants will be relatively high profile. While there's evidence from witnesses who work for two organisations, NSI and Tenaganita, expressing the view they would not be able to support financially the claimant's claims, the premise of their evidence is that they would have to provide much more financial support than would actually be required. What would be required here would be assistance with the basic fee and the filing fee. The basic fee, as you will recall, being the 1,000 ringgit figure, which is now attacked as being nominal, but I'll come to that. It seems to me reasonable to infer that they would be willing to support the claimant's claims if their financial contribution was far less than anticipated. So, as I say, the attack on that finding is based on, is in essence not against the judge's finding, which is not challenged, that the NGOs could fill the small gap required. And the references for that, those passages of the judgment are at footnote 39 of our skeleton. Then we move to ground 2B, where the claimants allege that it's wrong to conclude that there is no real risk that the claimants would be unable to obtain representation from suitably qualified lawyers in Malaysia, willing and legally able to represent the claimants on a partial CFA basis. We address this in our skeleton at paragraph 48. Broken down, there are a series of specific criticisms justifying that broad ground. The first, 2B1, is the erroneous conclusion, it said, that the proposed partial CFA arrangement would be lawful. This is the nominal point. And if you look at the way the judge approached this, it's one part of his findings that I've already taken you to, that CFAs have been since 2005 on the basic fee basis, nominal, lawful in Malaysia.
So sorry, which paragraph are we at?
We're now at paragraph 158. This is in the middle of the judge dealing with the lawfulness of CFAs, and he takes into account at 158 Chief Justice Malindrum's view expressed in the middle of that paragraph that the court would be likely to consider the quantum of claim, fee percentage, and so on, and the disbursement costs would also need to be considered. In his view, a basic fee of 1,000 to 1,500 would be entirely nominal and would give rise to a high risk of being struck down. So he takes that into account. Dato Malik's evidence is referred to at 159, as is Mr. Anath's evidence, also at 159. He then deals with the counter evidence that in relation to lawfulness of CFAs over the subsequent paragraphs, as I've shown you. But importantly, he addresses, and I've taken you to it, the evidence of Tony Woon, paragraph 164, page 119, who was the lawyer who'd been active with the Malaysian Bar Council and had served as chairperson of its ad hoc committee, who stated that the Bar Council had considered the basic fee and success fee model to be lawful. The retainer that was set in the draft rules was designed to ensure compliance with the case law, he explained that the minimum fee was not set by reference to the value of the case or the work involved, and so on. And the judge then makes his findings in 165 about the lawfulness of CFAs, and he deals with the nominal point at 167, where he holds that a realistic fee for the claimant of around 1,000 ringgit, and the defendant strongly supports that as a realistic fee. First of all, it's the fee that found approval in the case of Chai Chi Chin, which is the 2005 case approved by the Court of Appeal in Luar Mansur. It's also the fee level that's been proposed by the Malaysian Bar Council for non-personal injury claims, and I'll show you that, with personal injury claims being set at half that amount. So back in 2010, the Bar Council said, we will treat, in a circular, we will treat success fee arrangements with a basic fee as being lawful, and said that a lawful basic fee would be initially 100 ringgit, and then they said 500 ringgit at a later stage. And then in 2021, they updated that and said that a basic fee of 1,000 ringgit for non-personal injury actions would be lawful. So in short, the Bar Council, the Attorney General and the lawyers of Malaysia have been proceeding since 2005 on the basis that it's perfectly lawful and proper not only to enter into a CFA, but to enter into one on the basis of a basic fee at that level. And so if we just look at Tony Woon's evidence, it's in supplementary bundle, page 232. He notes in paragraph 8 that he served on the Bar Council of Malaysia in various capacities, and that he was, over the page on 234, Chairman of the Ad Hoc Committee on Conditional Fee Rules 2010 to 2013, Member of the Ad Hoc Committee on Conditional Fee Personal Injury Rules 214 to 218. And then he says in paragraph 9, in 210, a circular was addressed to all members of the Malaysian Bar about the Bar Council's position on proposed rules for contingency conditional fees, together with the proposed rules for regulating these fee arrangements. The circular and draft rules are exhibited. This document remains available to members of the Bar of Malaysia on the Malaysian Bar's website. He talks about the fact that by 2010 it had become very common for running down lawyers to charge low upfront fees and recover their costs, and there was concern about the uplift of profit costs. So on paragraph 11 on page 235, he refers to the July 2010 circular and what it said to the bar, and it's actually quoted in his statement at paragraph 13. The committee deliberated on whether the Bar Council would be in breach of section 112(1)(b by introducing the proposed rules on contingency fees, and decided to adhere to the Bar Council's view that a success fee arrangement, as that decided in Chai Chi Chin, is acceptable as the current law. So they were essentially telling the Bar, as long ago as 2010, that a success fee arrangement based on a small upfront payment would be treated as lawful. And then, as he says in 15, as to the proposed rules themselves, page 236, we set a minimum retainer fee of 100, This is to satisfy the basic fee requirement in Chai Chi Chin. And then he explains that in the following paragraph, that this was subsequently increased to 500, which is why Judge Kwai and the judge took as a reasonable fee 500 to 1,000, because it's increased, as I said, later to 1,000 for non-personal injury. It was not set by reference to the value of the case or the work involved. The minimum fee was not intended to act as a deposit for the balance of the fees or as a contribution towards disbursements. As the draft rules make clear, the remuneration of the lawyer in the event of success comes in the form of the receipt of the tax party-to-party costs from his or her opponents, as well as the success fee and the full recovery of all disbursements from the compensation. It was therefore not intended that the amount of the minimum fee would vary according to the complexity or value of the case. So he talks again about the modesty of the fee. He then says at paragraph 16, at the time of the 2010 circular, the Attorney General's Chambers had indicated they would support the introduction of those rules. And then in 17, to my recollection, while I was at the Bar Council, the Attorney General's Chambers never indicated that they considered that the success fee arrangements were unlawful or required amendment. He then considers the later reports and confirms that the position didn't change. He then says, paragraph 19, final sentence, I can see from the Malaysian Bar's website that an ad hoc committee on judicial fee rules for non-personal injury was set up, presumably to deal with this aspect, which is the case. In my experience, the success fee model is widely used today in Malaysia. It is most commonly used by firms that run personal injury claims, but it's also used in other practice areas. I understand that it's mostly used by plaintiff firms. I'm aware of a number of such plaintiff firms in operation in Malaysia that run cases on success fee basis and use the success fees from previous cases to fund disbursements in their current cases. Funding of disbursements by lawyers in these success fee claims is quite common, and there are several firms who operate in this manner. He then reiterates in 22 that success fee arrangements were lawful was the clear view of the Bar Council, the Attorney General's Chambers when I was a member, and that nothing's changed. And 23, finally, that the model was designed to represent the current legal position. I'm aware that Malaysian lawyers have used the basic success fee model in many different types of cases, including matrimonial, employment and commercial cases. Law firms may build up reserves. The model can be used to fund a large number of small cases in the inferior courts as well as cases in the higher courts. In short, I see no reason why Malaysian lawyers who use this model to run their firms and their cases, of which there is a significant number, could not use this model in the present case. And that was essentially the chimed with the evidence of Tun Arifin, Kwai, Chandra and Miss Chu, who exhibited in the appendices to her statement examples of cases, which I'll show you in a moment very briefly. So we've given the references to the evidence of Judge Kwai, but in essence, that's what he relied on when saying what he thought would be reasonable and that what the judge accepted as a basic fee. It's therefore quite wrong to say that the experts were agreed that the basic fee would be assessed on the basis of the complexity of the case and the size of the case. There was no such agreement, and there seems to be a misinterpretation of sections of Judge Kwai's report in which he is talking about the way in which lawyers agree fees and the way in which whether fees are reasonable pursuant to Rule 11 is considered. And that will take into account these factors. But Judge Kwai's evidence was that 1,000 was reasonable for a basic fee and not nominal because it accorded with the position of the Bar Council and the Attorney General's chambers, which reflected the current law back in 2005 and had been the law since. The references for that evidence that I've referred you to is footnote 44. The key paragraphs of Judge Kwai's first report, paragraph 59, and then 61 and 62. And I think the sentence that is being misconstrued is where he said in paragraph 61, I'm of the view that the quantum of the basic fee to be agreed would depend on inter alia, the quantum of the claim and so on. But he's talking about there to be agreed by the lawyers with their client. And he makes it clear in paragraph 62, in addition to this sum, the claimants would need to pay a basic fee based on the proposed Bar Council fee for personal injury claims set out above. This could be around 500 to 1,000, giving a total upfront cost of so-and-so. Simply put, I'm of the view that payment of a basic fee of 500 to 1,000 plus a filing fee would not be considered a nominal sum for the purposes of section 116 of the LPA 1976. And he confirmed that opinion in his supplementary report, Quai 2, paragraph 69 and 70, which is supplementary bundle, divider 10, page 175. I wish to reiterate my opinion, and so on. So in our submission, faced with that evidence, it would have been quite extraordinary for the learned judge to hold that, for an English court and the learned judge to hold that a nominal fee was in fact a figure that did not accord with settled practice in Malaysia and with the clear position, an undisputed position, which is not challenged in this court either, of Mr. Wu. In case you feel the need to look at it, can I just give you there's just 3 references for the Bar Council circular and rules themselves. The 2010 circular that I've taken you to is referenced at footnote 43, but it's the actual document is at supplementary divider 33, page 600, and the key pages are page 601, paragraph 5.2 of the circular at 602, which is the one you saw quoted, and at 602 you also see the definition, minimum retainer fee means 100. The rules themselves, proposed rules themselves, are at 614. You then, simply to show the uplift in respect of both personal injury and non-personal injury, you see the circular and revised rules of 2021, which is at supplementary divider 38, page 625, and that includes the position, a sum of 500 as the retainer payable upon execution of the conditional fee agreement. And then also in 2021 is the circular and rules for non-PI basic fee, which stipulate at supplementary divider 40, pages 627, 629, 632. And at 632 you see that minimum retainer fee means 1,000 ringgit or such other sum as may be determined by the Bar Council. So those are the underlying source documents that have been circulated to the Bar and have underpinned the evidence of Mr. Woon and former Judge Kwai.
And what's the maximum success fee that goes with the minimum basic fee of 1,000?
It's varied. I think it's 20 to 30%. Could I get that checked?
I thought it was 10% above $1 million.
Could I get that checked?
And a higher percentage below. I saw that somewhere, but maybe
Yes, I think Mr. Woon said that was the initial suggestion. When Mr. Chanda, apologies not doing his full name, said he would be prepared to do it, but for a higher success fee, did he mean a higher success fee than is permitted here or is suggested as suggestion by the Bar Council? Because obviously that's quite important.
He didn't expressly say, but I think one's entitled to assume that it would be a fair figure and would be, given that he's a respectable person, that it would be in accordance with Bar Council guidance. So, one moment, please. So I've dealt with the points in relation to the fact there was some sort of underlying agreement and justifying the judge's rejection of the claimant's evidence, but the narrow point that is taken by the claimants is that he shouldn't have rejected the evidence of Dhan Management that a basic fee of 1,000 would run a high risk of being deemed entirely nominal. In fact, this narrow attack is based on the fact that the judge took into account that Dhan Management could not point to any case law, which they say is a neutral and not a material factor. In our submission, the judge was right to take into account there was no case law to support Dhan Management's position. There is no case law to support his position. This was a material factor in circumstances where the judge found that there was judicial support for the 1,000 figure, which is not challenged. You've seen the evidence from Mr. Woon. The lack of case law for a different approach is all the more telling in circumstances where it's settled practice for Malaysian lawyers to act on partial CFAs with small basic upfront fees and a success fee. So in our submission, it was an entirely reasonable and fair point to take. It's then said that he shouldn't have treated the Bar Council position as a benchmark. I mean, in my submission, it's an obvious benchmark in view of the unchallenged evidence that the Bar Council was seeking to regulate an existing lawful practice. And on the contrary, it would have been perverse, we submit, to suggest that an English judge should have ignored the position of the Malaysian Bar Council, the rules that were proposed and to be adopted, a position which was approved in principle by the Malaysian Attorney General's Office and which reflected settled professional practice in Malaysia since 2005, and take a different approach. They then criticised the judge for saying, even if there was legal doubt about the matter, there's no evidence that this would deter legal representatives. Well, it's not necessary to deal with that criticism in any detail because, as you've seen, his unchallenged primary finding was that there was no legal doubt about the matter. And that's not challenged. They refer to the fact that Mr. Anand said he would have, at paragraph 140 and 159, where the judge referred to Mr. Anand, they refer to the fact that Mr. Anand said that he would be concerned about representing the claimants. Well, a number of his concerns were effectively rejected because they rested on alleged unlawfulness of CFAs. But what was telling about his evidence is A, that it was contradicted by the large body of evidence to which I directed your attention. But he did not refer at all to the position of the Malaysian Bar Council, despite the fact that it had been well publicised for many years, and he was a member of the Bar Council. So it's understandable why the judge did not think his concern was reflective of the position of Malaysian lawyers in general. And then the point is taken, and I touched on this, that it was wrong in principle to expect claimants to enter into an arrangement which may be unlawful, even if there are practitioners willing to do it. But again, that wasn't what the judge found. He found that it was there was no legal doubt and they were not unlawful. They were, in fact, SFAs were lawful and regularly used. And this is not a position that Mrs. Justice Lang faced in Unilever, where she said CFAs are unlawful in Kenya, and I ought to expect a lawyer to disobey that prohibition. He was dealing with a totally different situation. Then 2B2 is the 2021 position in relation to success fee. non-PI at 633 is 30%. PI is 20%, 625.
Thank you.
So this is the contention 2B2, the erroneous conclusion. So the claimants say that the claimants can obtain representation from suitably qualified and resourced lawyers in Malaysia prepared to act on the basis of the proposed partial CFA arrangement. It's put in those terms, but in fact when you drill down to what is said in the skeleton, it's a narrow attack focused on Mr. Chandra, because the judge's judgment is interpreted as effectively saying that only Mr. Chandra would take the case, and therefore various criticisms are made of Mr. Chandra in person. Well, I've taken you to the relevant unchallenged part of the judgment. You've seen paragraph 126 and his findings in relation to the Malaysian legal profession being active, skilled and public-spirited, taking on cases for migrants. I've taken you to 132, where the judge made findings that the cogency of the claimant's evidence was undermined due to the fact that they were applying a lesser standard. But in 132, he also said there was evidence that lawyers such as Mr. Chandra had argued complex cases in the High Court. The Goodyear case went to the High Court and the Court of Appeal, and I've seen no reason why a lawyer like him would not be suitably qualified to argue, and so on. If we go to 139 of the judgment, what he's doing here in paragraph 140 is taking into account the evidence of Dato Malik, and one of the points that is not disputed, and I took you to in the unchallenged findings, is that lawyers in Malaysia team up, and it's very common for lawyers from smaller firms to team up and do cases together. Far more common than, for example, it seems to be here. And he reflects the fact that Miss Dato Malik in 140 expressed the view that whilst lawyers from different firms did team up to act on a specific matter, he didn't think firms would be willing to represent the claimants would have the necessary resources to do so. They would only do so if the success fee was substantial enough for them to share it, given the need for revenue to operate and so on. He then deals with the counter evidence of Mr. Chandra, and again you'll note, and I'll give you the references are footnoted, but in 141, Mr. Chandra named 3 other Malaysian law firms who he said might be able to assist with the claims. He explained the likely charging structure, and he records the fact at the end of 141 that Mr. Chandra had actually taken a novel class action migrant worker case, Goodyear, on a modest deposit, and would strive to do the same for these claimants if they instructed him, as would other Malaysian lawyers. That's what Mr. Chandra said, who were committed to ensuring access to justice in Malaysia. And he says he considers the evidence of Mr. Chandra cogent, and he explains why. And he then again notes halfway through paragraph 142, he also specifically named a number of Malaysian law firms who might be able to assist, and Dato Malik did not dispute that these firms might be able to assist. And then he identifies the key concern of Dato Malik and the fact that it's addressed in Mr. Chandra's evidence. And it's in that context that he says this is the evidence of one potential lawyer only. It's the evidence of one potential lawyer that he's relying on to dismiss Dato Malik's concern. And you see that further from the fact that in 144 he concludes the latter's evidence, Dato Malik, does not provide cogent support for the proposition that there is a real risk that representation cannot be found for the claimants in Malaysia. And then over the page at 146 he says The fact that the Dyson defendants will prove to be difficult opponents and have no real limit to the resources available to them is unlikely to make any difference to the willingness of legal practitioners in Malaysia, such as Mr. Chandra on his own or with other law firms that he's referred to take the risk of representing the claimants. And again, you see in his stage 2 conclusions, paragraph 169, final sentence, up from the final sentence, there's no real risk that they, the claimants, will be unable to source suitable, qualified and expert legal representatives to take on their case in Malaysia on a partial contingency basis, with the fees and disbursements funded by a combination of the Dyson defendants through their undertakings, NGOs and the legal representatives themselves. The claim against the Dyson defendants is an important one, is likely to attract the interest of a number of Malaysian lawyers who work on migrant cases, including Mr. Chandra. And then finally in 170, he again refers to the fact that although the claimants are not currently in Malaysia, the names of Malaysian lawyers and the relevant NGOs are available to them via these proceedings. I have to assume that they will seek them out in effect. So in our submission, you can see from those findings that the judge, based on the evidence, was concluding that there were Malaysian lawyers, or likely there was no real risk there would not be Malaysian lawyers willing to take this case on an SFA basis, and that this is a practice that is common in Malaysia. Just dealing with the nature of the evidence in a case of this type, addressing access to justice. As a defendant, my Lord Master of the Rolls was in a time saying to me, if I may say so, we don't need to go into the weeds, we need to stand back and take a realistic view. And of course, there is a need to take a realistic view and stand back. But as a defendant, if you simply, one way of approaching a case of this type is to adduce a great deal of, as much evidence as you can, of a generalised nature from lawyers and others who operate in the legal system in the country in question, dealing with what forms of funding are available. That's possibly more straightforward, but also dealing with the willingness of lawyers to take cases on a CFA basis, say, just as you would if you were trying to demonstrate you could get access to justice in this jurisdiction. Now, in order to do that cogently, it is inevitable and necessary for that evidence to take account of the nature of the case. Otherwise, just being adversarial for a moment, what the claimants say is, well, these are just general assertions and they're not very cogent. So what you need to do in order to produce cogent evidence in this situation is to make it clear that those who are attesting to the lack of a risk that suitably funded and resourced lawyers will not bring the case have taken into account the actual nature of that case. And that is what is striking about this case compared to, say, Vedanta, Unilever and other cases, is that the defendants did put a great deal of evidence in because it was there for them to do so. Such evidence was available, not just of the more general propositions dealing with Malaysian lawyers, but also of a lawyer in the case particularly of Mr. Chandra, who expressed a willingness and ability to take this particular case. And in order for Mr. Chandra's evidence to be more cogent, obviously he has to say, I've been instructed what the case involves. One of the criticisms of the court in Vedanta, for example, was that there was no such evidence in Vedanta. But in this case, there was evidence from Mr. Chandra. He's one of a number of lawyers who are clearly available in a very vibrant legal profession, public-spirited legal profession in Malaysia, willing and able to take this case. But he's not conflicted out simply because, insofar as he is one of the contenders, he has been told what the case involves. He's simply been told what the case involves in order to enable him to give credible evidence on access to justice. He can't go further and say, and he's criticised for this, I will definitely represent these claimants, because obviously he needs to speak to them if they wish to instruct him as opposed to another lawyer in order to assess whether their claim has merits. So in some of the criticisms made of Mr. Chandra, which are premised on an erroneous interpretation of the judgment in any event, but insofar as they are focused on Mr. Chandra, we submit that they are not valid. There is no conflict in his case. He can represent the claimants. It's impossible for a defendant in our position to go further than say he is willing and able to do so. He's worked out how he would do so, but obviously it would be subject to agreement with the claimants. Otherwise, the bar of substantial justice is being set unfeasibly high, and I would submit flies in the face of what Lord Gough was referring to when he generally described what substantial justice is aiming at. There has to be substantial justice. But when you have a vibrant legal system and a perfectly accessible form of funding, there is, and CFAs is that form of funding, there's a limit to how far, in my submission, the court should go. Otherwise, you do have to disappear into the weeds. And it's impossible to satisfy the burden, or it puts an unrealistic burden on on a defendant. The evidence in support of the findings of the judge in relation to the availability of lawyers such as Mr. Chandra is referenced in footnote 48. And if I could just summarise it. First of all, it's the Chew 1 appendices at supplementary volume divider 8125, and as I touched on before, Appendix A at 125 is a list of cases before the Malaysian court involving claims by migrant workers. Appendix B is a list of cases involving multiple claimants in Malaysia. There is some overlap because some of the other claims are also group claims. And Appendix C is a list of legal practitioners who act for employees in labour and employment cases. I took you to the court's findings in relation to the challenges on those, and they were dismissed by the judge.
Mr. Gibson, I'm just a little worried about time. You're on 2B2, and you've got 10 minutes, really, if you're going to leave time for the reply.
Yes, I was proposing to stop in 10 minutes.
Okay, very good.
Is that fair for the reply?
Yes, it's fine. I just didn't want you to get carried away with one ground and then leave others out.
No. So that I've covered them, I'll come back to doing the references to that ground, but the other grounds are 2C, which is wrongly failed to have regard to the claimant's inability to attend trial in person. And that presents a real risk of injustice. We deal with that in our skeleton of paragraph 54. Paragraph 56. The judge took that matter into account. He referred to it. It's surprising ground of appeal given that the claimants themselves contended they would facilitate and fund the provision of evidence by the claimants remotely should the claims proceed in this jurisdiction. That's Holland 2, divider 8183. But in any event, giving evidence remotely is not a denial of substantial justice. Is my short answer to that point. 2D is the judge wrongly failed to have regard to the claimant's arguments that Malaysian civil process will not ensure the claimants are able to obtain disclosure of documents which are essential to establishing their case against the defendants. This is the disclosure ground which I didn't detect was being pressed too hard, and I can understand why, because a juridical advantage, even if there be one, is not a denial of substantial justice, as the court knows, on the basis of Connolly, Lord, and Spiliada, Lord Goff at 872 F. Sorry, it's Lord Goff in Connolly referring to his own decision in Spiliada, Authorities, Divider 3, page 88. But you've seen the case management model. The case management model contains a number of case management steps in relation to disclosure. They're all agreed, and there's no serious argument that Malaysian court system doesn't have a perfectly fair and effective disclosure system. Indeed, the highest at this point is put is in the evidence of the claimant's witness Dato Malik, that Malaysian lawyers, although being up to the challenge, may find it challenging, but there's no serious suggestion in the evidence that the Malaysian courts are not perfectly capable of dealing with applications, for example, for specific discovery, and that this could amount to a denial of substantial justice. And you'll see that it is largely agreed, the steps that can be taken in their response to the case management model are largely agreed. So those are the final two. So just in case I omitted them, apologies for taking them out of order. I'll just go back, if I may, and pop up the references for the to justify the important findings in relation to the availability of lawyers. You've then got, after Chu giving examples of the cases, they're not all in footnote 48, which is why I'm bothering to give them. You've got Chandra, Chandra 1, paragraphs 7, 8, 23, 26 to 28. That's, for example, where he says, I'd estimate there are 20 firms in Malaysia like mine who'd be able and interested to take on the sort of claims that have been issued in London in this case. As noted, paragraph 23, many lawyers in Malaysia act for workers on the basis that they receive an initial payment up front to fund the initial claim, and if successful, they recover a percentage. 26, I consider my firm would be able to manage the claims, but I note this would also be there would be the possibility of bringing in other lawyers to assist. If I needed more resources, I'd bring in temporary staff, as I did in the Goodyear case, or could cooperate with other firms. There is no shortage of lawyers, 27, in Malaysia who would be happy to work with me and my firm to assist in this matter. Indeed, should my firm not be able to assist due to some unforeseen reason, firms to whom I would happily refer the case such as this, and he identifies some firms. I'm happy to assure the court that I cannot foresee that these claimants would fail to obtain access to justice. I, like many of my fellow lawyers in Malaysia, would be concerned to ensure the claimants did not go without representation in Malaysia, and I'm confident that arrangements could be made for them to bring their claims in the Malaysian courts. He firmed up on that in Chandra 2 at paragraph 11.1 to 11.6, and that included the sentence referred to by the judge. He would strive to that same extent for these claimants were they to instruct me, as would other Malaysian lawyers like me are committed to ensuring access to justice. And he makes the same point. I asked the court to judge me on my record. As can be seen from Chandra 1, I took a novel class action migrant worker case of Goodyear on a modest deposit from first instance and on appeal, and I continue to fight for full compensation to this day. I strive to that same extent for these claimants were they to instruct me, as would other Malaysian lawyers who, like me, are committed to ensuring access to justice in Malaysia. Then there is Kwai 1, 27 to 33 paragraphs, and footnote 14, in which he identified certain firms who would be able to assist, and paragraph 72, And again, he attests in paragraph 31, for example, that well-resourced and experienced lawyers would be available to represent these claimants. Malaysia has a rich legal heritage and a strong legal profession who are more than able to deal with these claims. Indeed, much of this heritage is shared with the English legal profession. Many Malaysian lawyers have been educated in England, and many, including myself, have been called to the bar of England and Wales. He repeats the points, quae 2, at 76 to 81 of his statement. Again, testing to the ability of Malaysian lawyers to take a case of this type on a CFA and pay for the disbursements and resources suitably. And then Tun Arifin, former Chief Justice, at paragraphs, again referenced at footnote 48, but for your notes, paragraphs 39, 46, 57 and 70. Again, dealing with my Lord Master Rolls's point, paragraph 44, we also have many Malaysian lawyers that have handled cases involving multinational corporations and multiple claims or claimants. In my experience, most lawyers in Malaysia practice across a range of areas. In conclusion, I do not agree with Dato Malik where he says there are no suitably qualified lawyers who would be willing and able to bring this claim in the Malaysian courts. So I've dealt with the claimant's criticisms, in fact, all focus on Mr. Chandra. And essentially amount to saying he has a conflict, and I've dealt with those. They also mention the fact that the criticisms have been made of him in the way he handled the Goodyear case. Well, those criticisms were addressed by him in Chandra 2. They're from a non-lawyer NGO, Ms. Sridharan. They're wholly without substance. And you can tell that by two things. First of all, he achieved a successful outcome through settlement in Goodyear, as Mr. Pereira, the NGO who financed part of the claim, acknowledges at paragraph 15 of his statement. And secondly, Mr. Pereira then reached out to him on behalf of NSI to bring a second group action, the FNN case, which he's been working on. So that, we respectfully submit, rather undermines the argument that he had not done a decent job. Then Mr. Chandra, assuming he is going to be a person, or is a person which he is, willing and able to represent the claimants, said he is conspicuous because he doesn't say he would be prepared to act on the basis of a partial basis fee, but he deals with it in general terms, and in my submission with sufficient specificity, given the realistic position that he needs to assess the merits, having spoken to the claimants. I dealt with it, but at paragraph 55 of their skeleton, they criticised the judge for saying that Dyson defendants, they say the fact that Dyson will prove to be a difficult opponent and have no real limit to the resources available to them is unlikely to make any difference to the willingness of legal practitioners to take the risk of representing the claimants. They criticised the judge for that finding, but of course, as you can see from the evidence that I just touched on, it would have been entirely inconsistent with all the evidence the judge accepted and with his unchallenged findings that I've taken you to, if he was to not to make that finding, that further finding. Footnote 51 contains the references to the evidence of claims being brought against large corporations in particular, and there are further references at footnote 48. Yes, I omitted to take you to Aero Special in relation to undertakings. Could we just go quickly to Authorities, Volume 1, page 52. This was an anti-suit injunction, as you've heard, and the claimants were, one of the defendants was seeking to ensure that the claim proceeded in Brunei, rather as here said that they could bring claims against the manufacturer of the helicopter, which crashed, killing the claimants, that party not being susceptible to the Texan courts, so questions of forum through anti-suit injunction arose, and Air Especial, wanting the case to be in Brunei, gave various undertakings in circumstances where it was proceeding in Texas and had been for a while. It's against this backdrop that Lord Gough dismissed the Cambridgeshire arguments mounted by the Texan lawyers who'd been running the case, and I've given you the reference for that, but it's page 62. But what I'm dealing with here are the undertakings that were given, and they're summarised by Lord Gough at page 52, and you see just how extensive they are. And there's no dispute that they were in order to cure deficiencies or alleged deficiencies in circumstances just as with Dyson, where they were trying to ensure that the suitable forum was achieved. As you can see, to provide the plaintiffs with 2 irrevocable letters of credit drawn in their favour and confirmed by a first-class bank with Brunei in the terms annexed here too. And you see the letters of credit at page 68 and 69. There's a letter of credit in respect of costs and damages. That the Texas proceedings shall be permitted to continue until completion of pre-trial discovery.
I mean, we can read this, but you are really encroaching on Miss Kinsler's time.
No, well, I mustn't do that. Well, if I could ask you to read that in your free time, as it were, in your own time. Apologies. And the full undertakings are at the end of the law report at 67. That's a different case, different undertakings, but there's no suggestion that there's anything improper about those undertakings. There's no suggestion that the defendant giving them was not entitled reasonably to seek to ensure that his legitimate interests were protected by the proceedings proceeding in Brunei. And as you can see, they're different, but they are extensive, and it would have been possible to perhaps poke holes in them and suggest ways in which they might not work if there was unreasonable conduct on behalf of the giver. My lords, those are my submissions.
Well, thank you, Mr. Gibson. I assume we'll not be hearing from Mr. Heppenstall and Miss Foster.
You won't, my lord, I'm afraid. I regret that.
Next time, though, please
Yes.
give proper consideration to your juniors addressing part of the argument. It's a very serious direction from the Chief Justice that we like to encourage juniors to have the opportunity to do advocacy in the higher courts, particularly the Court of Appeal, for diversity and other really important reasons. Miss Kinsler.
I thought just a few words from me in reply on ground 1, and then a few words from Mr. Craven on ground 2. Firstly, in reply, my first point relates to the point made by Mr. Gibson in response to your Lordship's question as to why Dyson were objecting so strenuously to the claim being brought in this jurisdiction. And part of the reply certainly was in relation to the contribution proceedings that Dyson wished to pursue against ATA in Malaysia. We note, as your Lordships have already, that the judge found that the risk of those proceedings giving rise to inconsistent judgments was fanciful, not real. But just a few points in addition to that. First of all, the contracts which Mr. Gibson refers to are those which Dyson made it very difficult for us to see, which Mr. Craven dealt with yesterday. I draw to your Lordship's attention the note which was put in at first instance after the hearing on those contracts. It's in supplemental bundle, tab 1, page 6. No need to turn it up, but I'm just drawing your Lordship's attention to it. Among other points, that note refers to the fact that the contracts refer extensively to English legislation, so they're contracts between Dyson Malaysia and ATA, but they do refer to English statutes and statutory instruments. Secondly, the point about the jurisdiction clauses, your lordships have the point that one of the contracts has an arbitration clause in favour of Singapore in it. There was a question raised as to the timing of that contract, and I just give your lordships the reference to the particulars of claim on the complaints made by Andy Hall and the dealing of those complaints in response by the first and second defendants. That's the particulars of claim, paragraph 63, core bundle 10 at page 171. But generally, as the court knows, although the English court respects jurisdiction clauses very much, the court may, in appropriate circumstances, permit the joinder of a party, notwithstanding a jurisdiction agreement. And one of the important factors in that context, as the court knows, is the risk of inconsistent judgments. And so we say that's very much not a reason to say that it could not be in, or it's not appropriate for it to be in the English court. Even if there were related proceedings already going on, that couldn't be a trump card. These are indeed, at best, speculative proceedings. My second point relates to your lordship's questions to Mr. Gibson in relation to the reasons for the cancellation of the ATA contract. I took your lordships yesterday to Baker Mackenzie's letter to the claimants. That was at supplementary bundle 2, page 553, paragraph 5, and I didn't go back to that, but there are two additional documents I'd like to take your lordships to. The first is in supplemental bundle 2 at tab 45, page 656. It's a letter from Channel 4's lawyers to Shillings, lawyers acting for Dyson, in the libel claim. The letter starts at 651, it's dated the 9th of March 2022. If I could direct your lordship's attention to page 656. And there's 2 points on this page. First of all, the last paragraph refers to the audits by ATA and the fact that Dyson's position was that it was not until the RBA Elevate audit was conducted and shared in October 2021 that any key findings on forced labour were made. And we note that. We note the report has not been disclosed. And we note also, and draw your lordship's attention to little 8 further up that page, in which it is clear from the last couple of lines that Baker and Mackenzie, the solicitors for Dyson in these proceedings, interviewed Mr. Limbu before the letter of claim in these proceedings was sent, so on the 1st of October 2021. And your lordships will note there, Channel 4's law is saying at no time have you sought to contradict Mr. Limbu's account. And we say that very much goes to our grounds 1D and 1E, and indeed also 1B. That's before the letter of claim in these proceedings was issued. And there's one further document to look at in this context, which is in the same bundle at tab 90, page 800. It's Annex A to the re-amended particulars of claim in the live proceedings. And it's a schedule of financial loss claimed by the Dyson defendants, by the English Dyson defendants in the live proceedings. And your lordships will note A1, the costs of directly addressing reputational damage caused by the broadcast Tier 2 forced labour audit, 240,000 claimed. And down at the bottom, C, management time incurred addressing reputational damage post-broadcast. And then just turning over to page 802 to 3, your lordships will see a schedule of 35 employees in respect of whom management costs of dealing with the issues arising from broadcast are claimed, including at 33 in respect of the chief legal officer. So that's Mr. Martin Bowen, to whom I referred yesterday, and the sum of 6,500 or so is claimed in respect of his time. So we rely on those in relation to our grounds 1D and E, but also 1B. And my lords, just finally, responding to a couple of cases that Mr. Gibson referred to in his submissions. I'm not going to take your lordships to them, but just to give you references for your note. The Mercedes case on the question of the mixed case test, we draw your lordship's attention to paragraph 22 of that case. It's in supplementary bundle, or authorities bundle 4, I think, at page 89, and it's clear that that case proceeded on the basis of an agreed position between the parties as to the approach the court should take. Secondly, Mr. Gibson mentioned yesterday at the end of the day the case of Metal, which your lordships will be familiar with, and made a point about the substantial acts being in Malaysia. Metal's not in the bundle, but there is a quote, and the relevant quote is in the judgment of Mrs. Justice Carr, she was then in Tugashev, volume 2, tab 21, page 641, 642, paragraph 206. And the full quote is there, which looks to, so it's looking at the question of the tort ground for jurisdiction in relation to a defendant out of the jurisdiction. But what's made clear in that passage of Metal is substantial acts within the jurisdiction is enough, even if there are substantial acts elsewhere. A well-known point, but just to be clear on it. And thirdly, the case of Lubb and Cape in the Court of Appeal. Just want to give your lordships the references that we invite your attention to. It's volume 1, tab 4, page 94, the head note, and then pages 104 to 106 and 109. And we draw your lordship's attention to that on ground 1A and B. My lord, unless I can be of any further assistance, those are my submissions.
Thank you, Mr. Craven.
My lords, just some very brief points in reply on ground 2. One point in respect to the law. This afternoon, Mr. Gibson made an important concession that the test of substantial justice must import equality of arms considerations. And that is obviously particularly pertinent in this case, because there is a vast gulf between the parties. Claimants, who have essentially nothing, defendants, who in the judge's words have effectively no limit on the resources available to them. At the outset of Mr. Gibson's submissions, he took you to various aspects of the judgment and the judge's analysis on Spiliada Lim 2 that we've not expressly challenged. 2 points in relation to that. Mr. Gibson referred repeatedly to the judge's findings. The judge didn't make findings. He makes clear at paragraph 82 he's not making findings, so I'm not, in a sense, formally bound by findings unless I expressly challenge them. But the more important point is that I simply don't need to challenge what might be termed more generic or peripheral points on the access to justice reasoning. And that's why I took you at the start of my submissions yesterday to the judge's summary of his reasoning on the access to justice issue at paragraph 169, which makes it clear that really the nub of the reasoning is about funding disbursements and lawyers willing and able to act on this proposed partial CFA basis with a very small upfront payment. Ground 2A, disbursements and undertakings, 5 quick points. Mr. Gibson effectively conceded that the disbursements table does not reflect all of the disbursements that would have to be incurred in the pursuit of this claim in Malaysia. And so there was no challenge to my contention that the judge at paragraph 67 of the judgment has proceeded on the basis of an erroneous understanding of the total disbursements. And all the rest of the access to justice analysis is seen through that flawed prism. Second, the submission that it's in Dyson's interest to comply with undertakings. As the court observed during Mr. Gibson's submissions, Dyson's real interest is in the case failing. And in respect of the undertakings, it has both an interest, a financial interest in minimising its own expenditure, and a significant interest in maximising tactical advantage. And there's really no answer to that. Third, in respect to policing of the undertakings, Mr. Gibson said this afternoon that any arguments as to reasonableness of costs would be determined at the close of the Malaysian proceedings. And that really highlights a problem inherent in the undertakings proposal, which is that it seems if there's a dispute about whether expenses are reasonable, the claimant's Malaysian solicitors apparently would be expected to pay those costs and then await the resolution of the reasonableness of those costs at the end of the proceedings. Or in any event, if that's not right, and I can hear Mr. Gibbs saying no, there's going to be some uncertainty held over until the end of the proceedings about who ultimately is going to have to foot the bill for that. So we say that's a significant practical problem. Fourth, in terms of another point in respect to policing of undertakings, Mr. Gibson referred today to the possibility of the claimants coming back to this court to apply to lift the stay. We simply note that in addition to being procedurally complicated, there's a tension between that submission and what was said in the High Court. In the High Court, on day one, the judge asked whether the stay was permanent or whether it could be lifted if things did not work out in Malaysia. Mr. Gibson took instructions overnight, and on day two, the court was told that the defendant's position was that the stay was permanent and therefore could not be lifted. Now, I should make clear that question was put by the judge not specifically by reference to undertakings, but in a more general fashion of what happens if it doesn't work out and the claimants actually aren't able to access justice. And we can supply the transcripts if that's of assistance. Last point on ground 2A, the exchange this afternoon between my Lord Justice Popplewell and Mr. Gibson regarding issues of LPP really brought into sharp focus the profound and really effectively irresolvable problems from a professional conduct and legal professional privilege perspective. And it demonstrates the fundamental unworkability of these undertakings. Partial CFA's 3 quick points. Mr. Gibson said during his submissions that there have been a number of cases in which Malaysian lawyers have taken on tough corporate defendants on CFA basis. But in fact, there's just 2 cases referred to in the evidence in which a claim on behalf of migrant workers, group of migrant workers, has been brought on a CFA basis. It's the Goodyear case and the F&M Beverage case. Those are the 2 referred to by Mr. Chandrasekharan. Only in one of those do we know the size of the upfront fee. In Goodyear, the upfront fee was more than 18,000 ringgit. We know that because it was about 100 ringgit per claimant and 188 claimants. Goodyear, as I said, was a much more straightforward case. Breach of collective agreement claim in an employment tribunal context. But that upfront fee is more than 18 times what's being proposed as the basic fee here. Just for your note, the reference to the 100 ringgit per claimant is Mr. Chandrasekharan's first witness statement, paragraph 12.3, which is at page 112 of volume 1 of the SSB. Respect of the nominal basic fee argument, our key point is that the judge simply didn't engage at all in his analysis of this nominal basic fee question with the relevance of the complexity and value of the claim. Now, the counter-argument you heard today as to why complexity and value are irrelevant was based very heavily on draft rules, which A, are not enforced and have never been enforced, and B, have been made by a body that doesn't at present have legal authority to make those rules. And we say that it was incumbent on the judge in those circumstances to analyse and consider specifically the arguments that we advanced based on our expert evidence that the value of the claim and complexity were relevant. And we also note one further point in respect of this, which is that the evidence of other cases where there was a basic fee shows much higher basic fees. So in Dato Ma, as the defendant expert, in his first report, paragraphs 42 to 45, you'll see 3 cases where the basic fees range between 20,000 ringgit and 200,000 ringgit. Last point on basic fees is in his submissions as to availability, could the claimants find lawyers in Malaysia who would be able to represent them? Mr. Gibson elided 2 things. One is the question of whether there are suitably qualified lawyers in Malaysia who could do this kind of case. The judge says, yes, there are, and we haven't challenged that. But 2, the separate issue is, are there suitably qualified lawyers in Malaysia who would represent the claimants on the basis of a CFA arrangement with a very small upfront payment? And there is simply no evidence before the court referring to any lawyer or law firm who would be prepared to act in this case on that basis. I took you yesterday to Mr. Chandra's evidence. The high point of his evidence is that other law firms might be able to assist. He says nothing about the terms on which those other firms might be able to assist.
Well, if you're right about conflict of interest, they wouldn't be able to get that evidence.
Well, my lord,
without ruling out of court.
Well, he could give that evidence. He could, for example, say, I know of another law firm who has acted on this basis in a similar case, and therefore I have every reason to assume they'd be prepared to act on the same basis in this case. He doesn't say anything of the type. So that proposition could be established without having to get evidence from the lawyers themselves. I simply make the point that there isn't any evidence that points to a single lawyer, including Mr. Chandra, who would act on that basis. And last point on that is that Mr. Gibson referred to a list of cases involving claims by migrant workers, which was exhibited to the witness statement from Mr. Chu. That doesn't show that claims were being brought on a CFA basis, and really it's therefore irrelevant. We're not contesting that migrant workers can bring claims, have brought claims. Our challenge, our argument is that these migrant workers would not be able to find lawyers who would represent them on this basis to bring this claim in Malaysia. And that's the essence of our argument.
Thank you very much. Thank you.
I was just going to say, my lords, that I meant no discourtesy in not dividing up my submissions as your lordship.
It wasn't about discourtesy.
I didn't know where I would be or finish.
It's just a really important point for the future, and we're now in the future because this was nearly a year ago that we issued that practice direction. And by the way, it's been unbelievably successful, as today has shown, if I may say so, Mr. Craven. It's extremely good for juniors and extremely good for the court to hear from juniors. Yes. So next time, I'm sure we'll hear from your juniors, Mr. Craven. Now, can I thank all the parties and counsel and solicitors for the way this case has been very efficiently argued and helpfully argued for the court. It won't surprise you, we will take time to consider our judgments. When we hand them down, you will please comply with the terms of the embargo. It is extremely important that nobody who is not within the terms of the embargo is allowed to see the judgment, and that the judgment is only used for agreement as to costs and order, and nothing else of any kind. And you, if you can't agree, we will deal with all submissions that arise in writing and not orally. I think that covers it, and as I say, thank you all very much indeed.
Thank you.
All rise in favour